Hello everyone, welcome back to lecture 10 of CPC by Triti Dharya. In today's lecture, we will be covering the topic of execution. Execution is the most exhaustive topic under CPC and might be quite intimidating for a lot of people. But with today's lecture, we would be trying to simplify the same concepts and make it easier for somebody to remember and also understand the entire concept of execution. Before we can move on with execution, I hope all the previous concepts that have been covered in the last 9 videos are clear and there is no doubt. If there is a doubt, you can still come and post a comment or let me know personally that you want me to clarify that portion. We can do that. Now, moving on to today's topic, execution. I would firstly want to say that I would try to cover the entire execution in one lecture, but if it is getting a little too long than the last videos or in general it goes beyond 1 hour, 1.5 hours or so, I will break it up into two parts. Now let's go back. Let's before we can move on with today's topic, let's see something. What we have seen in the last 9 lectures is a very systematic progression of how you are seeing a suit being done or an application proceeding. You have seen the institution of it, you've seen the jurisdiction, you've seen the place of suing, pleadings, trial, issue of summons, appearance of parties, interim procedures, ending up into all of it and culminating into a judgment order or a decree. You've also seen the appeal, review, reference, revision, and all other provisions also. Now, here I would like to take an example, like if there was a property dispute between A and B. You have followed all the procedure, everything is there. The court or the judge who was authorized by law to pass a decision in that matter has adjudicated upon it and has given a decision that the property, that the title dispute between A and B is decided in favor of A and against B. Now, in this situation, you have to see that the mere writing of that statement of the judge in the judgment that okay, the property belongs to A, will it be enough if I do not in actual reality give that person A the possession of the property? It won't be enough, it won't serve A's cause. So that is why we have the provisions for execution. By execution, what do we mean by execution? Here we are trying to enforce or give effect to the judgment or order of the court. As we have already seen, like a lot many concepts, execution's definition has not been given under the code, but we can understand it in simple terms that you are trying to enforce or give effect to the judgment or the order of a court. Now, the provisions relating to execution, quite exhaustive, have been dealt in length under sections 36 to 74 and order 21. Order 21 is 106 rules. Now, with today's class, we'll be trying to cover most of it. Now, you remember when we were studying section 11, there explanation 7 was there saying that res judicata also applies to execution proceedings. You have to remember that because now you're studying execution in detail, so you need to fall back all those provisions that you have read before and apply wherever that is needed. So when an application is heard and finally decided, not like on grounds of non-appearance of parties and execution application is dismissed, etc., then when it is on grounds of non-appearance, etc., then res judicata won't apply. But where it was heard and finally decided, res judicata will apply. Now let's see what are the general provisions. Now what we'll try to do here before moving to the general provisions, we'll try to see which is the court, we'll see who is executing the same, and then in that systematic who will which is a court executing, who is a court who can execute, who can apply, etc. We'll try to move on in a systematic order. I have not put down the contents that this is the headings that we'll do, but you'll be able to understand as we move on with the lecture. So one of the general provisions here is section 36. Now when you see section, it is saying that whatever is a procedure applicable for execution of decrees, the same will be applicable for orders. Very simple, that is section 36. Now section 37 is defining a court which has passed a decree. Now, whenever any such word is used, it will be deemed to include firstly the court which passed the decree. If a decree was passed in the appellate jurisdiction, then the court of the first instance is taken as a court which passed the decree. So as you remember that we had said that in an appellate jurisdiction, it is a continuation of a suit and is taken as if the decree passed in the appeal jurisdiction was given by the court of the first instance only, like it is the first decree of that. when it is finally decided. So here, if it is an appellate jurisdiction decree, then it will be decided by the court of the first jurisdiction. And where the court which has passed the decree has ceases to exist or is no longer having the jurisdiction to entertain the same, whichever court now has a jurisdiction to try that suit will try the same. Now, there's another situation when a court's jurisdiction, there's a change of boundaries, etc., and the jurisdiction is transferred to another court's jurisdiction, then either of the two courts can entertain that application for execution. So this is section 37, which defines which is a court which passed a decree. The one which had passed the decree, if it was passed in an appeal, then the court of first instance. If the jurisdiction has ceased or it has no longer exists, then the court which now has a jurisdiction. If a part of a jurisdiction is transferred to any other court, then either of the two. Now we'll move on to the first main topic, that is courts executing decrees. Section 38, this will be reading the 37. You have done 37 right now. What is the definition of a court passing a decree? Which courts can execute a decree is dealt under section 38. In section 38, it is given that the court which passed the decree, where you will read section 37, and or the court where the decree was sent for execution. So which passed the decree and the court which it was sent for execution. Now we will move on. With this, you will understand that this shows that there is a transfer of decree happening. So we will now read the provisions dealing with transfer of decree for executions. That is section 39 to 42 and rules 3 to 9 of order 21. So section 39 is talking about transfer of decree. Now, whichever court has passed a decree, now the decree holder may apply that please send this particular decree for execution to another court which is of competent jurisdiction, because the person against whom this decree was passed is actually or voluntarily residing there or carrying on business there or is working for gain in that local limits. Or the person against whom this decree was passed has no such property in the local limits of the court which has passed a decree, and any such property that the person has in the limits of the other court to which I am asking for you to transfer. Or the decree itself is directing sale or delivery of immovable property which is lying outside its jurisdiction, or there can be any other reason which the court has recorded in writing. Now, when such a thing happens, what can that court do? That it can send it, or it can suo moto by its own self, it can send it to a subordinate court. If it is a court of a higher jurisdiction, like it is a district court, then it can send that, okay, I will send it to a particular civil court under my jurisdiction, I'll send it to there, it is subordinate to me, I feel that civil court will be better able to understand and deal with this issue, so I'm sending it there. Now, then we see that the court will be taken, how we will decide the competency of the court, that whether at the time of the transfer, does that court have jurisdiction to try the suit? If it have the jurisdiction to try the suit, then it is a competent court. Now, you can understand that there is, in simple, dealing with execution, a court only has jurisdiction to execute a decree which is related to property or person residing or is within its jurisdiction. It does not have authorization to execute a decree against a person or a property which is outside its jurisdiction. And just because you have come and applied, that the decree holder has come and applied for a transfer, does not mean that it is a vested right. You come and say that I want to transfer, doesn't mean the court will grant you the same. It is a discretionary right. Now we will see some more elaborations on the procedure. Rule number 3 is telling that if that particular property or land is situated in one or more jurisdictions, then any of the two courts can attach and sell the same. Now, rule number 4 is talking if you have to send it to a small causes court, you'll first see whether the pecuniary limit or whatever you're wanting to transfer, whether it comes within the pecuniary limits of the small causes court or not, and whether the subject matter is of such that the small causes court can deal with it. Now, rule number 5 is saying how do you transfer it? It is the mode of transfer. You either send the decree directly to that court, whether or not in the same state. So a court in Jharkhand, even if that other court where it wants to send the decree is in Andhra Pradesh, will send it there. Now, if the court where it was sent has no jurisdiction, now this particular court has sent it to a particular court in Andhra Pradesh, thinking that that particular court in Andhra Pradesh has the jurisdiction, but that court knows that it does not have the jurisdiction, and that court will transfer it to the court which actually has the jurisdiction. Now, what is the procedure when the court in itself is desiring that its own decree should be executed by another court? Then it will send the decree, it will certificate that this part of the decree, that satisfaction of the decree within the jurisdiction of the sending court has not been done or has been done in part, and then it will also send a copy of the order for execution of decree. And if there is no order for execution, then he will send a certificate that till now no execution has been ordered. The same. So rule 6, when it is the court is desiring on its own. Now the court to which the same is sent, the court to which the decree is sent, will see that it will not ask you to prove the same, that you have come for execution, etc. If I am already giving you the decree or the order for its execution or its copies, unless the court feels that no, there is something fishy, they feels there are special reasons to ask for further proof, then only it will ask. Otherwise, firstly, it will not ask for any proof, but only in special circumstances it will require such proof. Now, if such decree or copies are filed, that is rule number 8, and that court to which it is sent is a district court, what will the district court do? It will either execute it on its own or it will send to a subordinate court. And what happens if under section 9, if the execution by high court of a decree which was transferred to it by another court, it will execute it as if it was passed by the court in its original civil jurisdiction. Now, section 40 is talking about when you are transferring a decree to a court in another state. In which state you are transferring, you have to do execution according to its rules. Whatever rules are there in relation to execution, that you have to do. Section 41 is saying that whatever the result of execution proceedings will be there, it should be certified and it should be sent back to the court which had passed the decree, whether you could be able to execute the same or whether you failed to do so. If you failed, then why did you fail and what were the circumstances that led to the same. And section 42 is talking about the powers of the court in executing a transfer decree. Now, this is an important section. Why? Because you need to understand that is there a distinction between the powers of a court which originally transferred the decree and the one which was transferred the decree and originally passed the decree. I'm sorry, the court which passed the decree and in the one which was executing a transfer decree. Now, first thing, they have the same powers as if the court which had passed the decree and as if they had executed it. If any obstruction is caused by any person, they can punish it in the same manner as if the court which had originally passed the decree could punish it. And any order that this transferred court, this court which is executing a transfer decree is passing will also be subject to the same rules of appeal if it was executed by the court which had actually passed the decree. Other than that, this court can also send the decree for execution to another court under section 39, or it can execute the decree against the legal representatives or also order attachment of the decree. And any order if they are passing here, they will also have to send it to the court which originally passed the same. However, you have to remember two certain things, that it has no power to order execution at the instance of the transferee of a decree. Now, these are two provisions here. This you have to remember, this forms a part of quite a number of MCQs because in general the powers are same, but there are two exceptions. The court will not order execution if it is at the instance of a transferee of a decree, or secondly, if a decree is against a firm, then it will grant leave them. Then granting leave to execute such a decree against any person other than those referred in order 1, Rule 51 and C. So this is the two things that you need to remember. You can also see sections 43 and 44A, which is execution of foreign decrees in India, and then you can also see execution of Indian decrees in foreign territories, that is section 45. Now with this we have dealt with courts executing a decree. Here you have to see another thing, that an executing court cannot go behind the decree. Like, it has to execute, if there is a decree, it has to execute as it is. It cannot vary or modify the decree, or you can go into the correctness or its legality, because execution is collateral to a judgment. You are just enforcing the judgment, you're not checking the validity of the judgment. This is why you're not going into this correctness. However, if they are vague or ambiguous terms which they are not able to interpret as such, then you can interpret it accordingly, and otherwise you cannot question it. But if there is an inherent lack of jurisdiction which is very apparent, then you no need to execute the decree. in as the same as a nullity. You know, if there is an inherent lack of jurisdiction, the same as apparent will become nullity as it is. And territorial jurisdiction, as I said, is important because they cannot enforce or execute a decree against a person or property lying outside its jurisdiction. And also remember that the court which it has been transferred to also has the same powers. So this was the first head that we covered, where we are seeing, we first understood what is the definition of a court which passed the decree. There were 4 pointers there. Then 38 is causing which courts can execute a decree. Then we saw that because it is a court which passed the decree and where it can be transferred, we saw the transfer provisions. How can you deal with the transfer? Section 39, when the decree holder is applying for the same and it is a discretionary power. Then you saw the rules 3 to 9, different procedures when their land is in more than one jurisdiction. What would be the mode of transfer? What would be the procedure there? What will the court do there, when it has been given to it, etc. So this was, I hope you could understand what is dealt in the court's execution a decree. Now let's move on forward to application for execution. Now you saw the courts. Now we have understood which court is capable of executing a decree. Now we have to see, we saw that obviously the court will not directly jump into executing a decree. You will obviously require an application by somebody that please execute this decree that has been passed. And this particular portion, that application which will be presented by the DH, will cover under rules 10 to 25 and 105 and 106 of the order 21. So here we are seeing rule number 10. Application for execution, who is presenting? It is being presented by a decree holder to whom the court which passed the decree or wherever the decree was transferred. Now you can see 146 and 49 also here. So with the decree holder, you can see the legal representative can also go there, or the transferee of decree can also go there. Now rule number 11 is talking about an oral application. Generally these applications are written, but in what situation there is an oral application? Where the decree is for payment of money, then on oral application there might be either execution by arrest of the judgment debtor prior to the preparation of a warrant if he is present within the precincts of the court. So oral application, there is one situation where oral application for execution is allowed, where the decree was for the payment of money. Immediate execution by arrest of the judgment debtor is taken prior to the preparation of warrant if he was present at that time in court. Otherwise, it is always a written application. It should be written, signed, verified, like every other pleading or every other document, again written, signed and verified by the person, by the applicant or some other person who is there. It will also contain a tabular form which will contain the particulars, number of suit, name of parties, when date of the decree appeal was preferred or not, adjustments have been made, if any previous application was made, whether it was rejected, any interest was due, or any other relief or amount of cost, who is the person against which you are asking for execution, what kind of assistance do you want, whether you want delivery of property, whether you want attachment, whether you want sale, it's attachment and sale, arrest or detention, you want a employment of a receiver or any other relief. You have to state all of that in a tabular form. Then you will be also maybe required to produce the original copies of the decree. Now rule number 11A is saying that if you are asking for the mode of execution by arrest and detention, you also have to state the grounds for which you are asking the same. You have to write that in the affidavit, that I feel that this and this such and such thing will happen, this is why I feel an arrest is necessary, to also write that. Now if rule number 12 is telling you, now if there is an application where you want to attach movable property which is not in the judgment debtors provision, then possession, then you have to put an inventory of the property, you have to give reasonably adequate particulars so that you could identify that movable property. Now rule number 13, if it is for immovable property, obviously it should contain particulars for identification like boundary numbers, etc. And you should also specify, like if it is a shared property, what is the judgment debtor's interest or share in the same. Now rule number 14 is that you can power to require certified extract from the collectors registered in certain cases. Now rule number 15 is talking about the situation where there is an application for execution by joint decree holder, like whether it was in the favor of one or more persons, then any of them can apply for all unless any condition is already imposed on the contrary. And whenever such an application is allowed, that one person is being allowed to push forward an application on behalf of the others, court may order wherever it feels necessary that anything, whatever it feels necessary for protecting the interest of the others who have not joined in the application. Now, rule number 16 is talking where there is an application for execution by transferee of a decree. When the interest of a decree holder is transferred by assignment in writing or by operation of law, then a transferee can also apply for execution to the court which passed the decree in the same manner as if he was the decree holder. Now, when the transferee is filing such an application, notice needs to be given to the transferor and the judgment debtor, and the court will listen to the objections before allowing him to proceed. Now, if there is a decree for payment of money against two or more persons and that has been transferred to one, it will not be executed against the others. If you want to go into more detail about it, you can see the explanation under this rule. You can refer the whereat and go read the entire rule 16. Now, what is rule number 17 saying? Rule number 17 is dealing with the situation when what is the procedure when the court is receiving an application under rule 11.2. Now, court will first ascertain whether all the requirements under 11 to 14 have been complied with or not. If it has not been complied, then they will give it time to remedy the effect. If it is still not been done, court will reject the application, and once you have amended the same, it will be deemed to be taken that it was presented on the date when it was first originally presented, and all the amendments that have been made shall be signed and initialed by the judge. And if the application is now admitted, the court will enter the note date and it can order execution. Rule number 21 is talking about simultaneous execution, that a court can order execution at the same time against a person and also his property. Generally, sometimes the court is proceeding against the property, they'll not arrest the person, etc., or not put his personal liability, but sometimes they can order simultaneously both of the things can be ordered. Now, rule number 22 is talking notice to show cause against execution in certain cases, where an application of execution is made and this application has been made 2 years after the date of the decree, or is made against a legal representative of a party, or where the application for execution is under section 44A, or is against an assignee or a receiver in insolvency, where the party has been adjudged as insolvent, then the notice has to be given to the party against whom execution is applied for, so that that party can come and show cause why execution should not be done against him. However, there will be no notice required when on the lapse of 2 years if within the last 2 years there was some kind of an order that was given, or the legal representative case, the last court had ordered that the legal representatives will be joined, etc. However, court has discretion, can preclude the sending of notice for recorded reasons if it feels it will become unreasonable, or it will delay or defeat the ends of justice. Now, Rule 22A is saying that sale will not be set aside after the death of the judgment debtor before sale. But like, for example, if there was a service of proclamation of sale and after the service of proclamation the judgment debtor is dying, before the sale could actually happen, this would not set aside the sale. Rule number 23 is procedure of a issue of notice. If that person was issued notice under Rule 22, he did not appear, did not show cause, then the court will order execution. And if he appears in opposite objection, then the court will hear the objection and make any order as it deems fit. Rule number 24 is talking about process of execution. Now, all preliminary procedures have been done, then it will order the process for execution. Now there will be a process issued for execution which will have date of issue, the sign of the judge or the officer of the court, will have the seal of the court. It will mention the date on which you have to execute that particular process, or till the time limit in which you have to execute the same, and also the day when the same process has to be returned to the court, and process will not become void if there is a delay in return. And rule number 25 is where there will be an endorsement of the process by the officer in the manner and the day, when, how did he do it, what was the day of return, if there is any delay in return, why was it, and if it was not executed, what was the reason, etc. If we were unable to execute the same, then here the examination of officer can take place and witnesses can also be examined. Now, rule number 105, moving on to that, you are seeing that when a hearing of an application is taking place, a court had fixed a day. On that particular day which was fixed, or when the hearing was adjourned, applicant has not appeared, they can dismiss the application. If the applicant appears but the opposite does not appear, it will go ex parte. And rule number 106 is dealing with setting aside of ex parte orders. So order under rule 23-103, you can apply for setting aside the same, come and show reasons why you could not appear, then the court may impose costs, etc., or whatever it deems fit, and it feels so that okay, they are genuine legitimate reasons, we'll fix another thing. Now no order will be made here without giving notice to the opposite party. And this application for setting aside an ex parte order should be made within 30 days of passing of the ex parte order. If notice was served, if notice was not served, then within 30 days from the day the applicant has got knowledge of the same. So this was the second heading where we dealt with application for execution. What did we see here? We saw who is applying, we saw the decree holder, that is rule 10. Then we saw how are we applying, when we are allowing an oral application, when we are doing a written application. Then we saw if it is for arrest or detention, then you need to state the grounds also. Rule number 12 when it is for attachment of movable property. Rule number 13 for immovable property. 14 also you have seen. 15 if there is a joint decree holder presenting application for execution. Then rule number 16 when the transferee has come with an application for execution. Then what number 17 is saying that when you have received an application, what will the court do next? Then you saw the fact that under rule number 21, we also saw that simultaneous execution is also possible. Rule number 22, we see that there can be a notice to show cause in certain situations where an application is presented more than 2 years is elapsed or is against a legal representative, etc. And then what will happen after the notice has been issued, how the process will be executed, how the process of execution will be done under rule 24. Rule 25, how the process after the process has been sent under rule 24, how that will be endorsed by the officer. Rule 24, you have to also see the date of issue, sign of the judge, etc., how the process will contain the particulars, all of it are there. Then 105 is about the hearing that will take place, and 106 is about setting of ex parte order. So here we saw a systematic progression. We saw who is applying, what would be there, what would be the procedure there, if the process is being served, what will be contained inside it. All this we saw in this particular heading of application for execution. Now there is another topic, that is stay of execution. Now rule 26 to 29 we'll see here for stay of execution. Now when we stayed execution, now the court to which we had sent the decree for execution has sufficient cause, then it can stay the execution for a reasonable time. For doing what? For enabling the judgment debtor to apply to the court which had passed the decree, or the court whichever has the appellate jurisdiction in respect of the same, for order of stay or any other order. Or if a property or person of the JD was seized under execution, it may also order restitution or discharge of such a person pending the result of the application that he has given them. Now, before making an order of stay of execution or restitution of property, discharge of JD, court may also require some security, or it may impose any such condition on the judgment debtor as it thinks fit. So here we are seeing, till now we saw how the application was being done, how the process was being ordered. But there are certain situations where execution can also be stayed. So where it was sent for execution, they can stay for the reasons that you're giving the JD time to apply to the court by which the decree was passed, an appellate for stay or anything. Now while the stay is in operation, if something was seized, etc., then a restitution or discharge can also be done. And before making the same, the court may also require the person that you please deposit certain security, or certain conditions may be imposed on the JD as the court thinks fit. Now rule number 27 is talking about revival of execution proceeding. Just because in the stay application the liability of the JD or the JD was discharged as such, but his liability does not get discharged, his property or the person can also be retaken back. Now, rule number 28 is saying that the order of the court which passed the decree or the appellate court will be binding on the court to the decree was sent for execution. And rule number 29 is saying if there is a stay of a pending execution suit with a decree holder and the judgment debtor, then on terms of security or otherwise, it will be stayed till the pending suit is decided. Now, if there is a decree for payment of money, court will not grant stay unless you are first giving a security. And this particular for the payment of money, that first you need to give security. This was added by the 1976 amendment. So with this short topic, we are seeing that where do you first you see under Rule 26 is where are you taking your stay application. You're taking the stay application to the court which passed the decree or the court which is having the appellate jurisdiction. You're also seeing that whatever decree, order or anything that is coming from that court will be binding on the court to which it was sent for execution. What was the reason for doing so? What will happen if there was something already seized? Then it can be discharged or restituted pending the result of the application. And the court may also take security or impose any other condition also. If there is another suit that is pending in relation to the, if execution is going on, for example, to explain section 29, the execution will be stayed because there is some pending suit between the debt holder and the judgment debtor which will decide some right or issue that is there. Then it will also security in terms of security or otherwise as it deems fit. So this was what we have dealt with, stay of execution. The next topic that we'll cover is questions to be determined by executing courts. This is an important provision. It is first you have to understand that it will only arise for matters which have arisen after the passing of the decree. Here it will deal with objections that you have to the execution process, to the discharge or the satisfaction of the decree. Now here you are doing it in the same proceeding only. You are not asking for a separate proceeding. We are trying to avoid unnecessary litigation. It is a wide and exclusive jurisdiction, and whatever questions that are arising between parties to a suit and representatives which are relating to execution, discharge or satisfaction of decree can be determined by the executing court. So the first thing that you have to remember, all those questions which are arising after the passing of a decree, not before that. Those questions which are relating to execution, discharge or satisfaction of decree, that only will be dealt by the executing court. So here we'll see firstly what is section 47. Now all questions between the parties to a suit or the representatives which are dealing with the execution, discharge or satisfaction of the decree will be determined by the same court, and there will be no separate suit for the same. Now, if there is a question whether that person is a representative of certain person or not, this will also be determined by the court executing the decree. Now, plaintiff whose suit was dismissed or against defendant against whose suit was dismissed are also taken to be parties to the suit. Now, for this particular section only, purchaser of a property at a sale in execution of a decree is also taken as a party to a suit. Now, all questions relating to delivery or possession of such property by such purchaser or representatives are also deemed to be falling under this ambit. And we already saw what is the object of the same, and it has a very wide scope. The two conditions, as always, it should be arising between the parties or the representatives in a suit in which the decree was passed. Here, this parties or representatives not only means the legal representatives, but it can also mean heirs, executors, administrators, transferee of interest, etc., who is bound by the decree, and it should relate to the execution, satisfaction, or discharge of a decree. Now, it is not explicitly defined, but it can cover questions like whether this decree can be executed or not, be its satisfaction, whether the party is entitled to restitution or not. Now, just as is it important to understand some examples that what questions can be dealt by executing court, it is also important to understand some examples that what cannot be dealt by the executing courts, or what are the questions not relating to execution. So the one of the examples that executing court cannot, one of the examples of a question that an executing court cannot deal with is whether a decree is fraudulent or collusive, or whether the question is relating to the pecuniary or the territorial jurisdiction of the court which has passed the decree, or where we are trying to check the correctness or the validity of a decree, except where in itself is a nullity, etc. So this was section 47 that was there. Now we can see what are the parts of the executing court. Now all such questions which are relating to execution of decree, but only to matters subsequent to the passing of decree, that is executing court can decide. But what are its duties also? It will not go behind a decree. It will execute it as it is. It will not dispute its correctness or validity. If it is vague, etc., it can interpret the same. Inherent lack of jurisdiction, obviously, it can again refuse to do the same. Previously, a determination of a question under section 47 was taken as a decree and was also appealable, but this was removed by the 1976 amendment. And in the 2 clause 2, which defines a decree, there also it was deemed that such a decree or such a order or decree order that has been passed by a court in such a proceeding under section 47 is also taken as a decree, or that is it becomes a deemed decree, but that also has been removed. So here we have seen another topic of questions to be determined by the executing court. Very important to remember, section 47, the number becomes important. What are the questions, between whom this question should lie, and what these questions should relate to. You can see some examples in the section itself and some examples that we have dealt here. What is the object, we can understand. What are the powers of the court, what are the duties of the court, and that the appealability, its deeming as a decree and its appealability was removed by the 1976 amendment. No, so now, till now, what have we covered? We saw the courts which can execute a decree. We saw the application for execution. We have seen the questions, the stay of execution. We have seen the questions that can be determined by the executing court. Now let's see how. Now let's see how and understand that how execution will be effected. So what are the different modes of execution is the next topic. So first thing that we see is that the modes of execution, that what are the different modes of execution has been dealt under section 51. We see that delivery, attachment and sale or attachment without sale, arrest and detention subject to the period specified in section 58, appointing a receiver or any other manner as a court deems fit are the different modes of execution as has been stated under section 1. Now we also need to understand that a court always allows, it's not necessary that just because the court told you that you can only go for appointment of a receiver, that is the only mode of execution. You can go for two modes of more than one mode of execution also. And a decree holder has the option to choose by which mode he wants to go, but it would be subject to the limitations and the conditions prescribed. Now, so 51 is a wide scope, and the court which is passing the decree will not ordinarily try to restrict the modes by which judgment can or decree can be executed or limit the modes of execution. It can also allow simultaneous execution. But despite all of this, that it is giving you entire freedom to come and choose your mode of execution, etc., the discretion of the court is still there, that it can refuse the execution at the same time against the person at the property of the JD, or it will only not allow you to proceed simultaneously in one or two modes. So this was section 50. Now let's try and understand its modes of execution, how for particular kinds of property, how we will go for execution in a tabular time form. So one kind of mode of execution you saw is delivery of property. That will be for movable property or immovable property. Now, apart from that seizure and delivery, we'll also see what are the additional modes that can be used. Like for if it is a specific movable property, where you seize and deliver it to the person, or you attach a particular property, or you detain the person in a civil prison, or you will order both attachment and detention. Now, if this attachment is staying in force for 3 months and still there is no payment or no delivery of property by the judgment debtor, now the decree holder will apply for sale. That property of the judgment debtor will be sold, and whatever amount was there, that has to be money that has to be given in alternative to the same, will be given to him, and some compensation may also be given. Now, if the judgment debtor is obeying the same, he's paying costs, etc., then at the end of 3 months, if no application was sale for made, or if an application was sale for made but was rejected, the attachment will cease. So I hope you are not getting confused at why I have written delivery of property and then gone into point attachment, etc. It is that for a specific movable property, first you go for seizure and delivery. After that, if it is not happening, then you can move for attachment. If that is also not happening, then you can go for detention, or you can go for both of them. Now, if this attachment is for 3 months, then you can and still nothing has been done, you can also go for sale, and for whatever amount that was stated in the alternative can be given to the person. Some compensation may also be awarded. If this has been already been done, the judgment debtor then pays off within those 3 months. Then at the end of the 3 months, if any no application was sale for made, or if it was made and refused, then the attachment will cease. Now in the similar manner, we'll see for immovable property. Here also delivery is one of the modes in respect of immovable property. However, actual or constructive delivery will also do. Now, if there is, we are seeing for delivery, in the process of delivery, there's certain person who is refusing to vacate that particular property, and you can also remove that person. Now, if there is that particular property is in joint possession, how will you give effect to delivery? You'll go and affix a copy of the warrant in a conspicuous part of the property. Then you'll go proclaiming by drums or any other customary mode what has been written in the decree, that from now this date onwards, this property is being delivered to so and so person. Now, if this person, whoever is there, is not allowing access, then first you'll give that person warning that I'll break into it. Then you'll also give the pardanasheen women or women who do not appear in public as such, give them time so that they can report and they are not affected by your barging, etc. Then you can remove, open lock, or break into any other things. Then rule 36 in respect of immovable property, like if it is a house that is now being delivered for, it is not that means been decreed in your favor, but at that point of time it is in the occupancy of a tenant who is entitled to that particular occupancy and is not bound by the decree to relinquish his occupancy. Then in those cases, how you will deliver that property? You will go and affix a copy of the warrant in a conspicuous part of the property, and proclamation by drums, etc., at some convenient place about the substance of the decree may be taken. This was about delivery of the property. Now, as under section 51, we saw that the next mode is attachment and sale. Now, attachment and sale can be done, or attachment without sale can be done. So this, in a way, you can see that first you need to attach, then only you can go for sale. But it does not mean that if in a case the sale is being done without the attachment, will become void. It will just be an irregularity. Now another mode is arrest and detention. Now, for example, if there was a decree for payment of money, and in that case you have applied for the mode of arrest and detention, first what the court does, it will give a notice to the judgment debtor that you come and show cause why you should not be arrested. Like for examples, when will you use such a mode, like for why you should not be sent to prison, and if the court feels so that he's saying right that why you should not be sent, then they'll not give you that mode of execution, or they'll order his detention. Now, what are the certain situations in which you can go for arrest or detention? Like when they'll be obstructing, where the court is seeing that you are obstructing, that the judgment debtor is obstructing or delaying the execution by either absconding or leaving the local limits of the court, or after the institution of the suit has dishonestly transferred, concealed, or removed any part of the property, or has done any other act of bad faith in relation to the property. Or apart from this, he does have the means to pay the entire amount or a substantial part of the amount, but he is refusing to do so, neglecting to do so, or whatever sum was there was such a sum that the JD was bound in a fiduciary capacity to account for. In those cases, you can go for the mode of arrest and detention. I hope this is also clear. Now, appointment of receiver is another mode that we had seen. So this is an exceptional remedy. Like first, you need to show the court that no, the rest of the remedies won't be favorable for me, rest of the modes would not work for me, so please go for this one. You can go through order 40 rule 1. Now, what happens if it is a partition decree or a separate possession of a share of an undivided state? Now, in this case, because if the payment of revenue is being done to the government, then this partition or separation of share will be done by the collector. Now, cross decrees and cross claims, I think I forgot to deal with it in detail. You can go through these particular rules. That is, for cross decrees, you can go through rule 18 and 20, and for cross claims, rules 19 and 20. If there still remains any confusion, please let me know, or I'll try to cover it in the next lecture. Then the next thing that is there is payment of money. Now, for example, if there was a decree for payment of money, simply like the decree was for payment of money or payment of money in alternative to some other relief, then in these cases, there can be attachment and sale of property of the judgment debtor, or his arrest and detention, or both can be done. Now, how do you pay this money? You either deposit it in the court, or you give it out of court, or any other direction that the courts give. That is rule 1. Then this particular payment or adjustment that you have given, a certificate will be given for the same. A recording of the same by the executing court is essential. Without this recording, it will not have any value. Or the judgment debtor himself will come with an application that please record such a payment or adjustment. And when the judgment debtor is coming with such an application, notice will be given to the decree holder that come and show cause that why the same should not be recorded, that now the decree has been satisfied, etc. If the decree holder is not coming, then the court will record the same. Now the another issue where there is decree for specific performance of the contract. Now if that particular person who has against whom the same was issued has willfully disobeyed it, then his property may be attached, he may be detained in civil prison, or both may be done. Or if it is against a corporation, if a corporation was asked to do specifically perform a particular contract, he has not done so, we'll deal it later. Now if there was a decree for an injunction, now what in the case of an injunction, if the party against whom it was issued has willfully disobeyed it, or then you either execute it by attaching his property, detaining him in prison, or doing both. Again, for corporation, we'll be dealing it with later. Now, restitution of conjugal rights. If a situation where the conjugal rights were restituted, a person who willfully disobeys the same, you'll attach his property. For restitution, family matters, etc., there will be no sending to civil prison. Otherwise, the entire object of restitution will fail. Like if I have ordered two people to stay together, and because that person is not obeying, I take him to jail, then how is it solving the purpose? This is why only attachment here and no sending to civil prison. Now execution of a document, where the decree was for execution of document, the judgment debtor is refusing or neglecting to do the same, court will give opportunity both of them. Then it will prepare a draft according to the decree, and if the court has prepared a draft of the document according to it, then the same will be executed as if it was executed by the party who was ordered to do the same. Now what happens where the decree was for endorsement of a negotiable instrument? Here the judgment debtor is refusing or neglecting to do so. Both of them will again be given an opportunity. They'll prepare a draft, will be prepared in the same manner endorsed as if it was endorsed by the party who was originally ordered to do the same. Now, if there is a decree for unascertained rent, mean profit, or any other such matter, then the court may order attachment of the property of the judgment debtor before the profit amount of money is already ascertained. Is still unascertained. Before that has been ascertained, then till before that only attachment will be ordered. Now, what could be the liability of a surety in such a situation? Now, if a person had furnished some security or given a guarantee for performance of whole or a part of a decree, or for restitution of any property taken in execution, or payment of money, or for fulfillment of condition, then under the order of a court, decree can also be executed against such a person who had furnished a decree or given a guarantee, and he will be taken to be a party as per section 47. And decree here can be against the personal liability of the judgment debtor, or sale of the property furnished as security, or for both. Now we saw what will happen in the case when the decree is against the corporation. Then the corporation's property can be attached, or there can be detention of a civil prison of the officers or its. So for a decree against a firm, it can be executed against a partnership property, or the person who has appeared and admitted himself to be a partner, or he was served as a summons as a partner but he did not appear. For any other person, if you want to go against him, or you can want to execute against him, and first you have to show what capacity his liability is there. First you have to show his liability as a partner. You should remember suits against a partnership firm. There you'll see why I'm saying his liability as a partner should be proved first. And a property of a firm can be attached or sold when it decrees against a firm or a partners, but doesn't affect those partners who were not served summons to appear and answer. Now, what will happen if the decree was for payment of money or sale and enforcement of a mortgage of sale, and when that particular decree itself is the property to be attached? Now, this can be done by the court, which had passed by the decree, or by an executing court can do so by sending a notice to the court which had passed the decree. Here, what are we doing by attaching the very decree is that we are trying to prevent the decree holder to take away the fruits of the decree alone and safeguard the interest of an attaching creditor. Like a creditor who has interest against a decree holder, then here we are trying to attach a decree holder's decree only. Here we are trying to attach a decree in itself only, so that it will prevent the decree holder to take away the fruits of the decree alone. Now, what in the case of payment of coins and currency notes where the same comprises of properties to be attached, the same may be paid for satisfaction of a decree. Rules 1 and 2 I have dealt in detail here, but for payment portion where we have done in the table, we have done it there. You can go through this later on, but first let us go back and see what did we read in modes of execution. First we have seen, where did it go? First, let's see section 51, that delivery, attachment and sale, attachment without sale, arrest and detention, appointing a receiver or any other matter. Then we saw different modes. We saw for movable property, we are seizing and delivering, attaching or detention in civil prison. Then we are seeing the 3 month situation. Then in the immovable property, we are seeing the delivery, and you can vacate, remove a person who's refusing to vacate. If it's a joint possession property, what did we do? If the person is obstructing, not allowing you to enter, what you will do? If it is there that it is in the, so for immovable property, you either deliver it to a person, or if the person is, somebody is not refusing to vacate the property, you can remove that person. If it's a joint possession property, what will you do? If the person is not allowing you to enter the access or give you access to the property, what would you do? Or if it is in the occupancy of a tenant or somebody who is bound, not bound by the decree and has the right to occupy the property, what would we do? You saw that in that also. Then we saw attachment and sale and attachment without sale as a mode of execution. Then we saw arrest and detention. What would you do? That you first give a show cause before doing the same. And what are the situations in which the court may order that arrest and detention should be given a mode of execution? We saw all of that. Then we saw how appointment of receiver can be done and what situation. What happens if a decree of partition or separate possession is there? Then the collector will be doing the same. Then cross decree and cross claims. I already said that if you want a clarification, please let me know. But these are the relevant rules. Then if there's a payment of money, then how you are paying that money, how the certificate needs to be recorded, why, how will it be, the decree will be enforced, that is by attachment or sale of the property of the judgment debtor, or at detention, civil prison, or both. Rules 1 and 2 were dealt here. You can go in detail. I have dealt after the table also. Specific performance of contract, how are we doing so? By attachment of property, detention in civil prison, or both. In the injunction also, if there's a willful disobedience, then here also attachment of property or detention in civil prison, or both. Restitution of conjugal rights, very important to remember, only attachment, no detention in civil prison. If there's an execution of document and there's a neglection, if there's a neglect or refusal on the part of the judgment debtor, then first the court will give opportunity and then prepare the draft on its according to the decree, and it will be executed. Same in the cases of endorsement of a negotiable instrument also. Now, if there is a decree for unascertained rent, means profit, or any other things like that, there will be attachment of property by the court even before the amount is ascertained. Now, liability of a surety is also there, where you see that not only against the party but also against the surety you can proceed against. Then against a corporation, there you will attach a property or detain in civil prison the director or the officers, or both. And against a firm, you will see that how you are doing so, that against the property, the person who is appearing and admitting as a partner who has served a summons as such and did not appear, or any other person, you to first show his liability as a partner. And here the property of a firm can also be attached and sold. And if the decree itself has, if there is a particular decree which it has self has to be attached, where you're doing so, so that the decree holder is not taking away the fruits of the decree alone, how will it be done? And the last we saw payments of coins and currencies, that the same may be paid for the satisfaction of decree. Now, rule number 1, we have dealt here in detail. You can go through it if you want, that how you will be, what are the different modes in which you are paying money under the decree. Like you can either deposit it in court or outside the court, or in any other matter as the court directs. If you're paying in court, etc., you with the judgment debtor will give notice to the decree holder directly or through the court by registered post acknowledgement due. And the day you send the notice, from that day you do not have to give a notice interest on the same. And if it is paid by bank or postal order, all particulars, that which is original suit number, name of parties, all those details, number of execution, which court, all of that, who has to pay, who is paying, who is his address, etc., has to be given. If you're paying outside the court, the day you are making the payment, from that day, you would not have to give any interest. Now, if the decree holder is refusing to accept whatever payment you're trying to make, then the interest will also cease from that day. Now, rule number 2 is saying if the payment is out of the court, the first decree holder would have to certify such payment or adjustment that is being made, and the court will record the same. Judgment debtor or a surety can also apply and inform about the same. Here, notice will be sent for show cause to the decree holder that tell us why it should not be recorded, why if you are failing to, and if the person fails to appear or fails to show cause, then the court will the same. Now, no payment here will be recorded at the instance of a judgment debtor unless you can show that the payment was made in accordance to rule 1, or if the same was proved by documentary evidence, or it was admitted in part or whole by the decree holder in reply to the notice that was sent, or by himself in court. Now, if any payment or adjustment has not been certified or recorded, it will not be recognized by the court executing the decree. I hope with this you are able to understand the different modes by which we are going for execution: delivery, attachment, with sale, without sale, arrest and detention, appointment of receiver, and any other modes. We have seen different kinds of decrees like partition, restitution of conjugal rights. So basically, there can be different kinds of decrees as we discussed above, but the modes are some few modes that we have discussed under section 51 that you have to remember. Now we will be going into arrest and detention, sale and attachment into detail, and those will be the next chapters that will be covered. So with this, this part you should be able to understand that we have covered what we have covered. First, we have understood which are the courts who will be executing the decree, what would be the procedure for the application, how a stay will be taken, what are the questions an executing court will be doing, and we have understood what are the different modes. Now, with whatever topics we move on now would be an elaboration into the modes of execution. Next lecture, we will move forward to the elaborate discussions into the various modes like arrest and detention, sale and attachment. That would be the topic for the next lecture. I hope till now you have understood all of these topics that we have covered. I hope till now you have understood all the topics that we covered. You have been able to understand the execution process, and this is all clear. This is your base. Now we are going to build up upon it, that we'll be going into details of arrest and detention, etc. So let's move forward and meet in the next part of this lecture, where we'll be going with firstly with the detailed provisions relating to arrest and detention, sale and attachment. I hope this lecture was clear to you today. You did not find any errors, and in case you want me to deal with cross decrees and cross claims in a little more detail, please let me know. We will do that in the next class. And I hope there is no other problems with the lecture. Please leave your review. That's it for today.